All right. Happy Thursday. Today's topic, the 2026 Florida Realtors Compensation Agreement update. So today's discussion, just to give you guys a little foreshadow on where we're moving on our objectives today. Specifically, our objectives are to look at the updates that are specific to the compensation agreement. So the buyer brokerage agreement and the seller compensation agreements. Those are the two items that we're going to look at today. And then, secondly, what's important for us to look at today is enforcement of the compensation agreements. I want to make sure that you guys we're not just going to go over the updates because they're less, we got a little bit of the updates themselves you should know, but the second part of what's important today is knowing the framework around enforcement of the compensation agreements, right? Not just what they say, making sure they're signed, but am I making sure that the agreements are signed in a manner that I have some teeth for enforcement? All right. So that's our goal for today. Because I'm positive that we talked about this a few times, but we have to keep having this conversation just to ensure that we're clear on how we're protecting our compensation. All right. So I see a lot of course, familiar faces in the room, but if there's anybody new, anybody I have not had a chance to meet before, I want to virtually introduce myself to you. My name is Ray Cole Jackson. I'm a South Florida real estate attorney. I'm a little bit about me personally, my background, and how we landed here in Purchase Ready Lab. I am originally from Florida, attended the University of Florida, so I always say go Gators. Went to law school in California, where I was the founder of the Real Estate Law Society. Have always had interest in real estate. Came back home to Miami and got my LLM in real property development from the University of Miami School of Law. A proud licensed Florida realtor, got my first real estate license in California during law school, and also a proud licensed Florida mortgage loan officer. Got my license the first time before I went to law school. So, most of you, many of the realtors with you in the room, they know that I own and operate a title company, mortgage brokerage, of course, a law firm, and real estate brokerage affiliated with, of course. All right. So, with that being said, the conversations that we have each week are very much 360 degrees, right? They're not limited in scope to any particular part of the transaction. We always have a focus. But if there's something that I need to ensure that you guys pivot and look at from either from the lending side or from the title side or from the legal side or the transaction side, then we're going to have that conversation. I want you guys to also feel free to ask those questions. All right? All right. So today's handout. Grab it, purchasereadylabhandout.com. If you want to type it in, here is the QR code if you want to scan and jump to the link from there. So purchasereadylabhandout.com. If you go there, drop in your information, the handout will come up. Today's handout is the exclusive buyer brokerage agreement. Of course, it is our overview graphic. It is going to be our exclusive buyer brokerage agreement. It is going to be our rider GGFF, and it's going to be our compensation agreement that we're going to discuss today. So make sure that you grab that. All right. So a little recap on our changes. So we know that in 2024 we had a ton of changes. 2025 we had a good amount of changes. A combined about 90 updates were made to the Florida Realtor Forms Library between 2024 and 2025. In 2026, we have 17 updates to the Forms Library. So those not 17 updates to the compensation agreements themselves specifically, as well as, thanks, Sophia, as well as um, not 17 changes to the compensation agreement specifically, but 17 changes to various documents, right? So there's riders that have been updated, there's been forms that have been created. Want you guys to know how these changes are made. And so there are about four main ways that changes are made to our forms library. We have changes based upon legislative and statutory changes in laws, right? So new state laws or local ordinances will impact changes. So for example, Miami-Dade County, when Miami-Dade County, this was years ago, Miami-Dade County had changes to what they required to be in the deed related to assessments. We had a rider for that. We don't see it as much anymore, but that's an example of changes to a local ordinance that impacts our forms template library. Of course, NAR policy changes. We know the largest change has been regarding buyer brokerage agreements, and so we had a slew of changes to our documents as it relates to NAR policy changes. Then there are changes that the committee decides are needed, and then there are changes that are peer driven, meaning the members themselves. Realtors are calling in and they're calling into the legal hotline. They're making there is a form change suggestions form in form simplicity. If you guys probably scanned over that, but just from recommendations from the realtor community is another way that changes are made to the forms. Right. So now to the forms themselves. It is important to know the difference, distinguish the difference between the exclusive buyer brokerage agreement and the seller compensation agreement. Understand their difference and their uses. In any particular transaction, if you represent a buyer, you could potentially have both of these. And I'm going to tell you that you should. By the end of our discussion today, you will know that you should have both of these documents as well as one of the writers specifically, right? But to level set our conversation today, we know that we are talking about the buyer's brokerage agreement and the seller compensation agreements today. All right. So we know that the exclusive buyer brokerage agreement is related to defining the representation type that the buyer agent has um, with the buyer. So if you do me a favor and drop the link in the chat, we have a lot of people coming in. Drop the link in the chat to the handout, purchasereadylabhandout.com. Exclusive, thank you in advance. Exclusive buyer brokerage agreement, we'll also call it EBBA for the purposes of today's discussion. Again, it defines what is the representation type the buyer and the buyer's agent has agreed to, as well as what is the compensation that the buyer and the buyer's agent has agreed to. All right. And then the seller compensation agreement that is focused on thanks Sophia, that is focused on defining who's going to pay the buyer agent compensation and what is the amount of compensation that buyer agent is being paid. All right. Exclusive buyer brokerage agreement. It's the agreement between the buyer and the buyer agent. What is the representation type and how much am I being compensated? How much is the buyer's agent being compensated by the buyer? Seller compensation agreement. Who is compensating the buyer's agent? And what is the amount of compensation that they are agreeing to provide to the buyer's agent at closing? All right. On the screen, you see our four types of exclusive buyer brokerage agreement versions. Today's class, we're not going over the buyer's brokerage agreement. If you have not taken a class where you have reviewed line by line the exclusive buyer's brokerage agreement, you need to take that class. I recommend that you take that class regularly. I would say quarterly because it's a lot of information. And you are going to be explaining this to consumers who this is foreign to them. Like you hear this every day. We talk about this every day. This is the first time they're seeing this document. This document is 3 pages, small print. They're going to have a lot of questions. And so, what is best for you is to really internalize and understand this language because the better you understand this language, the better you're going to be able to explain it to your customers when it comes time to execute this. I want to reiterate because of the NAR settlement, whereas you would just jump in the car with the buyer or have them follow you and you go see a property and you knew that you were being paid by the seller because of how the MLS compensation section was set up, that's no longer the case. You must now have what I call a meeting of the minds. Now, if you have a buyer that you can just email this over to them and they sign it without asking you questions, that's possible, but I'm not sure that that's the type of buyer that you want. The buyers, if you send this to me, I'm gonna say, well, what is this and what am I agreeing to? There's a lot of spaces and numbers and percentages and if thens, right? So again, if you've not taken a class on the exclusive buyer brokerage agreements, how to present them, then you need to take those. And then again, I recommend that you take it quarterly, even specifically like a contracts class. All right. For the purpose of our conversation, know that the exclusive buyer brokerage agreement transaction broker form is the most common form of buyer's brokerage agreement that we utilize in Florida. It's similar to the as-is contract, right? The as-is purchase and sale contract is used in 99.9% of residential purchase and sale transactions. Similarly, the exclusive buyer brokerage agreement transaction broker form is the most commonly used buyer brokerage agreement template. It is the agency type is limited representation. You represent the transaction. So you don't have what we call a fiduciary duty to the client, to the buyer, which is what, for example, you would have in a single agent relationship. You have full fiduciary obligation to your buyer when you sign a single agent, meaning I exclusively work with you. I'm not going to work with a seller on the same transaction, right? Um, Not common. Again, we know this one is the most common. So then you also have, of course, the no brokerage relationship. This is where, for example, you're just facilitating the transaction for administrative purposes. I would say this is similar to the when a seller puts their property on the MLS. They don't want you to do anything else, just make sure it hits the MLS, right? And then the EBBA consent to transition to transaction broker. This is when you've signed a single agent agreement with the client, and now you are transitioning to transaction broker. All right. All right. So that's the four. Those are the four forms. Again, that's just a recap. So you know the four that are out there. If you have not taken a class or you review them line by line, you need to do that. So, what are the updates to the exclusive buyer brokerage agreement? We have three major updates to the exclusive buyer brokerage agreement. Number one, paragraph 5B. There was language in there that the buyer understood that the broker could run their credit. That's been removed. It's not to say that you cannot run a credit check as a part of your business model. If that is part of your business model, running credit is common with what leases, right? So if you're utilizing a platform that allows you to do like a soft check on a buyer on a customer's credit, you can continue to do that. However, you're going to need to manually insert that into the additional terms section of the buyer's brokerage agreement. Many of you probably doesn't even um, relate to any the way that you do business, so doesn't impact you much. But for those of you who do run credit, you know that that language is no longer now in there by default, and you will need to add it in. There's also been added at the bottom a acknowledgement of receipt. It creates a procedural assurance proving that the customer received the executed document. All right. So, like delivery receipt, we now have that at the bottom of the buyer's brokerage agreement. One of the other changes is there's now been a section added to paragraph 5 making the client, the buyer aware, consumer aware that when you visit a property, that property may have camera and audio surveillance equipment installed. Because why? People are making comments, good, bad, and indifferent. When they're making good comments, it's impacting their negotiating power. Seller heard how much they love the place. Now you try and come back and play like you don't really care about it too much. Well, they heard you say, "Oh, so you agents, you need to put them on notice that there may be, which is very common, there may be audio or video recording equipment in any of the properties that we tour. For that reason, use discretion as we move about the property with what both you say and what you do, right? Use discretion. I would highlight that. And I would have them initial next to that section, right? So they won't say, did you tell me that? Yeah, here's your initial. Use discretion. From the sidewalk, you guys know that you can walk on in front of the sidewalk of people's homes and then woo, because they have that much range, right? So that has been added to the buyer's brokerage agreement. All right, let's drop this in here. We got a lot of folks coming in. So here's what I want to make. Here's one of our major points to know and understand today, our objectives. To understand enforcement issues related to the buyer brokerage agreement. Now, I know some of you say, "Well, Cole, I thought you said it was so wonderful, like it was so well written." Well, it is. It is well written. However, the buyer brokerage agreement does not create, its flaw is that it does not create a contingency to closing. It's not linked to the purchase contract, meaning if a buyer goes rogue, you cannot prevent the transaction from closing, right? You have no way of, again, creating a block between this transaction closing and you being paid if a buyer goes rogue. It's just the nature of the beast right now, right? Could there be some language drafted for some other repercussions? Sure, but we're not there yet. So we need to be clear on the fact that the buyer's brokerage agreement is a standalone agreement between the buyer and the buyer's agent, and the contract, the purchase contract, is a standalone agreement between the buyer and seller. These two do not link to each other. Are we clear? I don't want to move too far. Are we clear? If you're not clear, say, I don't understand what you mean. All right? All right. I guess we're clear. So here's another visual. We do our buyer's consultation. Buyer's brokerage agreement is executed. Wonderful. They've agreed to pay you 10%. I mean, you're just amazing, right? We go, we show property, we have the purchase and sale contract executed. Again, these do not link. They do not link. Reiterating, the buyer's brokerage agreement does not inherently create a contingency. And let me not assume that you guys know what contingency means. We know what contingency means, right? In plain English, contingency means this must happen so that this happens. This must happen in order for this to happen. You must do this in order for me to be required to do this. That's a contingency. The buyer's brokerage agreement creates no contingency. Nothing must happen with that buyer's brokerage agreement in order for the contract to close. There's no contingency. It's broken. There's no continuous chain there. All right? So, for that reason, in every transaction, you should be looking to utilize one of the riders. Rider GG is an agreement that a compensation agreement will be executed within 3 days. And the rider makes the contract contingent on that agreement, the compensation agreement. The rider, I'm going to say it again, the rider makes the transaction, is creating the bridge. It makes the transaction contingent upon the compensation agreement being executed. That's rider GG. Rider FF, you're not doing both of these. Rider FF is a credit related to compensation. And both of these are in your handout. If you guys are just coming in the chat, we have a link to our handout for today. All right. So Rider FF creates a link between the purchase contract and your buyer's brokerage agreement, because Rider FF says that the seller is going to give a credit that's going to be used towards compensation of the buyer's agent. Are we clear on that? Are we clear that we're now creating a link between the buyer's brokerage agreement and the contract? We're creating a link either via Rider GG or Rider FF. I recommend Rider GG, but you need to be taught both of them. All right. All right. Now, we've discussed the buyer's brokerage agreement. We've discussed the riders. We know that that Rider GG is linking to the seller compensation agreement. What are the updates to the seller compensation agreement? We used to have 4 seller compensation forms. We had seller to buyer's agent and then the modification. And then we had seller's broker to buyer's broker and then the modification. All 4 of those have been consolidated into 2 forms. We now have the compensation agreement, seller or seller's broker to buyer's broker. So we just put those 2 in one, and you're going to choose which one it is. Is it the seller to the buyer's broker, or is it the seller's broker to the buyer's broker? And then we have the one modification. Okay, so we went from 4 forms, seller to buyer's broker, and seller's broker to buyer's broker, to just one form. And you're going to say which one are you choosing. And then we went from a modification of those for each of these to just one modification to this one form. All right. So we have one compensation agreement, one modification. It eliminates what was being referred to as form fatigue. You're trying to have to figure out which one where. So now we're just one and one, right? Now, with that being said, it's important that you must select an option. So make sure, hopefully, if somebody has two, if you don't have 2 screens, you'll see when you go to the compensation agreement, paragraph 1, you need to choose who is the party to the agreement. Who's paying the compensation? Is it going to be the seller or the seller's broker? You must select one. You can't leave this stuff blank, guys. That's one of the first uh, tenets that I teach you guys as it relates to contracts. Do not leave blanks. There's no reason for that. Even if if an agreement has default language, if left blank, if that's the number that you intend to use, write it in. Do not get in the habit of leaving blanks ever, right? All right. So for the first section of the compensation agreement, you're going to choose who is the agreement between. Is it between the seller and the buyer's agent, or the seller's broker and the buyer's agent? All right. Then they've added a section, the listing status. Is the property listed by the buyer's broker? Property is listed by the buyer's broker. The property is not listed. Of course, well, not of course, but it's listed most times, right? Buyer, broker. But you're going to choose which of these it is relevant. Now, the next update, the third update, is the term of the agreement, because this compensation agreement it's an agreement. It's an enforceable agreement. So previously it was enforceable for 30 days. It's been updated to 15 days. That time by default, it's been updated. The time period, the term has been updated to 15 days. Now that's negotiable, and you can always change it back to 30. You can make it 45, 50, 60, whatever. But by default, know that the compensation agreement has been updated to a term of just 15 days. Within 15 days, we expect you to go under contract in order to the seller to be required to compensate you for for procuring the buyer. All right. So those are the 3 changes to the terms within the compensation agreement. Outside of consolidating 4 forms into 2, within the body of the compensation agreement, those are the 3 changes. Now, I see that question. I'll answer that question when we get to it, because I need some clarity on the question in the chat. All right. The compensation must match. Remember when we first started, um, when I said if the buyer agreed to 10%, well, if the seller, let's say the seller agreed to 20%, I mean, you're just phenomenal, right? You're just phenomenal. Like you're getting people to agree to some just astronomical compensation numbers. Well, you can't be, the seller cannot pay you more than the buyer has agreed to pay you, right? In no event will buyer's broker's compensation exceed the amount of compensation in buyer's broker's separate written agreement by the buyer. That is in the body of your um, compensation agreement. That's at the last paragraph, right under paragraph 7. Broker commissions are not set by law, fully negotiable. In no event will buyer's broker's compensation exceed the amount of compensation in buyer's broker's separate written agreement with the buyer. What does that mean? That means if your buyer, let's say for example, you agree to 2%, let's use more common numbers. Let's say the buyer agrees to compensate you 2%. The seller has agreed to compensate you 3%. What needs to happen here? We need to modify that buyer's brokerage agreement to 3%, right? Because in no event will buyer's broker's compensation exceed the amount of compensation in buyer's broker's separate written agreement with the buyer. They have to match. They have to match. Now, the buyer can agree to pay you more than the seller, but the seller cannot pay you more than the buyer has agreed to pay you. Are we clear on that? Buyer can agree to pay you more. Seller cannot pay more than the buyer has agreed to pay.
Hi, this is where I'm a little bit confused because if the buyer already signed, okay, because they signed that they agree that I to pay me 3%.
Mm-hmm.
The seller says I'm giving 2%, right?
Mm-hmm.
So now, as per the agreement, I'm going to get 3%, two from the seller and one from the buyer. Is that correct?
Correct.
Okay. Now, if the buyer agrees to pay me, if the seller agrees to pay me 3%, I call the agent, okay, what's the commission? She says 3%. Do I still fill out that form as I'm from, I have the buyer sign that I'm getting 3%? Or if the buyer was paying me 4%, for example, do I put 4% on that form at that point?
On which form? So let me answer the first question. If the buyer has agreed to pay you 3%, seller's paying you 3%, there's nothing to do. They
Okay,
match.
I agree.
Your next question was buyers agreed to pay you,
4%,
okay, what is seller paying?
3%.
Okay. What do you think? Before I tell you the answer, what do you think is the
I'm
outcome?
thinking that the buyer will pay me that 1%.
That's the answer.
Okay. Now, when I present that document, and that has happened to me, and I tell the buyer,
Presented
well,
to who?
when I present to the buyer, to my client, to the buyer,
Mm-hmm.
that okay, that form, and I'm saying, okay, you're paying me 3%. They're like, no, I'm not paying you 3%. Now I have to explain to them that no, you're not paying me full 2%. That is my fee. This is my professional fee that I'm charging. The seller will be paying either 2% or 2.5%.
When
You
do you
will be
tell them that? When do you tell them that?
at the time that I'm discussing the agreement with them.
You don't want to do that. At what you mean, like the buyer's brokerage agreement?
Yes.
You don't want to say that. That's not the way to frame it. Because they have agreed to pay you. Full stop. From there, the conversation is now, in light of that, what you can direct me to do is, of course, number one, always negotiate with the seller who will compensate me enough to cover what you've agreed to pay me. You don't ever want to make them feel like they don't owe you, that they're not, they haven't agreed to pay you. Does that make sense? You never want to say that. Because remember, I taught you guys before, what if you go to a property? They love the property. They absolutely love the property. Seller is dead set. They are not giving one penny towards your compensation. Now, what are you going to do? Because you told them, no, yes, you've signed this saying you're going to pay me 2.5, but the seller's going to pay me. Does that make sense?
Right.
You never frame it that way.
This is why it's always, tongue-tied explaining it.
And that's why you have to practice. I'm glad you asked the question. That's why you have to practice. That the best, and this is not just for you, this is for everyone. You script the language that you are going to deliver to the buyers to explain to them, yes, you're signing an agreement. Due to NAR regulations and rules, you have to sign an agreement with me for me to represent you, and we confirm how much I expect to be paid. Now, with that being said, there's a mechanism for us to ensure that we only go under contract with properties where a seller has agreed to cover the cost of the compensation that you've agreed to pay me. Are you directing me to do that? Here's how that works. When we go before we go see properties, we'll ask if the seller has already agreed to compensate me. If even if they say no, I'll negotiate with the seller and request a compensation level that will cover what you agreed to pay me. Does that make sense?
Mm-hmm.
And you make sure that they continue to understand that. And if under any circumstances we are negotiating on a property where the seller just absolutely will not agree to make any type of contribution towards my compensation, I will let you know that. And ultimately, you will have to decide whether or not you want to proceed with that, with going under contract for that property, understanding that you're going to be responsible specifically for paying my compensation. I can tell you as a general matter, in most cases, sellers are contributing towards buyer's agent compensation. So the likelihood of you having to go down that path, now I definitely have transactions where the buyer has paid a portion of the buyer's agent compensation that was short of what the seller was offering.
Mm-hmm.
Not many at all where the buyer is paying all of it. It's just not happening. Not say it cannot happen. Not say it cannot happen because I've
Right.
closed them. I'm just telling you it's in very unique circumstances. All right?
So so that I'm clear, so I let my client, my buyer, know that I'm going to find out what is the seller willing to compensate me for my services.
Correct.
And I'm going to tell them if they will not pay my full commission, the difference is yours to cover.
Correct.
Okay.
Nicole, can I ask a question on that?
Absolutely.
So let's say the seller that does agree to pay the 3%. Where in chapter 7 of the BBA does it specify that the seller is going to pay?
You're saying compensation. So last line of paragraph 7, it says compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph. Line 7 of the last line of paragraph 7 of the buyer's brokerage agreement. Give me 1 second, I can pull it up here. I think I still have it up on this screen.
So we could just point that out to the buyer, say, listen, I'm going to get the seller to pay that 3%.
Yeah,
It's here.
yeah,
Okay.
yeah. Compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph.
What paragraph are you reading from?
Paragraph 7, last line of paragraph 7 of the buyer's brokerage agreement.
First
If anybody
paragraph.
is not if anybody doesn't have the handout, make sure you go to the handout.
That's important.
Paragraph
Here,
7, the last
paragraph
line.
7, last line of paragraph 7 on the buyer's brokerage agreement. Matter of
And
fact.
in the first paragraph, not after all the A's and the B's and the
Oh,
C's.
sorry. Yes, 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 yes. In first
Oh,
paragraph.
okay.
Matter of fact,
That's
let me just do this. Let me go here because I know I have it up. Hold on one second. Uh,
Compensation received by broker.
all right. Give me one second. Did I close it? Hold on one second because I know I had it up.
Okay.
Oh, oh well, guys, I closed it. I had the document up and I've deleted it from my desktop. But you guys see it, right?
Yes.
Okay, great. So I can go back to the slide deck. All
stop.
right. So let's move along. Let's back up. Hold on. And we're going to have a Q&A section as well for any other follow-up questions. And we're pretty much at the end anyway, so we didn't lose any time with that. All right. So we now understand the caps concerning compensation. Again, it's not to say that you cannot, period, ever be paid more than what the buyer agreed to. It's to know that you're going to need to make sure that you put the other documentation in place to be paid, which is a modification of the buyer brokerage agreement. All right. All right. So let's talk seller compensation agreement enforcement. Now, how do we enforce the seller compensation agreement if there is any friction? Now, recall you just told us that to bridge the gap between my buyer's brokerage agreement and the transaction and the purchase transaction, the purchase and sale agreement, that I should use Writer GG and a compensation agreement. Yes, I did. That is the best way under the circumstances. However, even still, that doesn't prevent a seller and a buyer from going rogue. It just doesn't. It just doesn't. It's just like any other contract. I had a client say, well, he signed a contract. I know he signed a contract, but the enforcement of it is the next step if they don't abide by the terms that they've agreed to. All right. So, as a general matter, if there is a dispute regarding the compensation agreement, the seller compensation agreement, not the buyer's brokerage agreement. If there is a dispute regarding the seller compensation agreement, we have two paths for resolution. If we selected seller to broker in paragraph 1, the path to resolution is first mediation. Mediation, as a reminder, is the parties going to a neutral third party who's going to hear both sides of the story. Seller side, buyer's agent side. The mediator is going to say, here's how I suggest, here's how I recommend that you all resolve this dispute. But it's non-binding. You don't have to listen to them. You can say, you know what, mediator, whatever, kick rocks. I still think I'm right. I'm going to take this to court. That's the next step, is litigation. You take it to court. Now you can sidestep litigation, which is costly, takes longer if the parties have agreed to arbitration. Arbitration is similar to mediation in that third party neutral, they're now a decision maker. They're not making a recommendation, they're making a decision. I hear your side, I hear your side. Here's what the law says, here's my decision. Okay? So again, if we have selected if it's a seller to buyer's broker agreement, and those are the parties to the compensation agreement, if there's any dispute, we're going to mediation first and then either litigation or arbitration if that option is selected. On the other hand, if we've selected seller's broker is compensating buyer's broker, and those are the two parties to the compensation agreement, then we're going to arbitration. We're going to binding arbitration pursuant to NAR. Okay? We're going directly to arbitration to resolve that dispute. Now, I recommend for compensation agreements that you do broker to broker. Somebody tell me why. Why do I say broker to broker?
Let the brokers fight it out.
To avoid mediation, litigation.
Also, what else?
Hold the broker responsible, I guess.
Say that again.
Hold the broker responsible.
In essence, yes. You always want to go to in litigation, we say who has the deepest pockets? Who has the most to lose by not going about this the right way? And it's the broker, right? They have the most to lose, they have the deepest pockets, they have the most exposure, they have the highest liability as well, right? They have the highest level of fiduciary duty to ensure that this transaction, that they abide by the terms of the compensation agreement, right? So a seller, yeah, I mean, you can enforce it, but just think about what that looks like, right? Trying to even enforce this. Let's say you even win, and we don't even want to go down that rabbit hole. Yes, you win, but how are we going to collect? You guys do realize that when you get a judgment, you just get a judgment. Now it's time to, there's a next step. Now I need to collect on this judgment. All right. Broker to broker is just a cleaner path to not only a decision, but also recovery. All right. So again, remember, because agents cannot halt a buyer seller closing, the seller broker responsible party sets up just a safer structure. Brokers are just not likely to go rogue on that. Are we clear on that? All right. So again, it's not to say at the end of this conversation today, it is not to say that a buyer can't go rogue by execution of these documents. It's not to say that a seller or even a seller's broker can't go rogue. But what is the theme of our trainings this month? Get it in writing. Because once you get it in writing, now we have a remedy if someone goes rogue. Right? If you don't have it in writing, then I can't, you start calling and texting me. I'm like, sorry. All you got was a buyer's brokerage agreement and the contract. What am I supposed to do with that? Like we can go after them, but we now with the buyer, we have to go to mediation and then arbitration or litigation. It's the same thing, right? Versus you tying this together. And now we just have more teeth. Now we have more teeth. We have more teeth. So here's our checklist. If we've agreed, if we're being compensated by the seller or the seller's broker, here's your checklist. Of course, you're going to have your buyer's brokerage agreement executed. Of course, you're going to have your purchase and sale contract. You're going to have, remember, you're going to have Rider GG. And I would recommend that you do seller's broker. Now, I do want to put a caveat here. Some brokerages, or I know one at least, EXP, I'm not sure if they've changed their position on this. They do not allow broker to broker. It is their position that broker to broker is essentially the same issue that the Sitzer-Burnett case created, which is transparency. Their position is we want the seller to understand that they're compensating the buyer's agent. Sitzer-Burnett says sellers didn't understand that they were compensating a buyer's agent. And so EXP's position, again, unless they've changed, is that they do not allow their agents to proceed with broker to broker. So if you can't do this, then you can't, you have to be compliant with your brokerage. However, if you are with a brokerage that has no prohibition against broker to broker compensation, with Rider GG, you're going to select seller's broker. And with the compensation agreement, you're going to select seller's broker. Is that clear? Right? Scenario B, if your compensation is being paid by a seller credit, which is not as common, but it's an option, so you need to know it. You're going to have your exclusive buyer's brokerage agreement executed. You're going to have your purchase and sale contract executed, and you're going to have Rider FF executed. You're not going to have a compensation agreement executed. Why don't you have a compensation agreement executed? Somebody tell me why.
Because the credit is going to cover what you're supposed to get as a commission.
Exactly. 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 You don't have a compensation agreement executed because the seller has not agreed to a compensation. They've agreed to a credit that the buyer is going to use towards closing costs, which includes your compensation that they're responsible for. All right.
Lender might put a limit on that compensation.
Right. We have that here. Ensure credit does not exceed lender limits. And the writer also has language around what happens when you hit a limit. It goes to the buyer's agent. So there's built-in language for that. All right. All right. So recap visually. We've a lot of talking. I don't know about you guys, but often I'm most when I'm trying to figure out when I'm understanding a concept, I'm a visual learner. So, visual recap, how we have all of this clicking together. We have the buyer's brokerage agreement. You go from there to your purchase contract. Now, in that purchase contract, you're going to have your rider, right? Your rider GG or rider FF. Again, FF is least common, so we're going to assume that your rider GG. And that rider GG is linking in that compensation agreement, right? So we have a fluid documents that are linking together. All right. All right. Remember, you always have access to Florida Realtors legal hotline if you have questions. I told you guys before, make sure that you save this number in your phone. They have, I think, like 11 full-time attorneys that are waiting to hear from you guys every day, every weekday, Monday through Friday from 9 a.m. to 4:45. Make sure you save this in your phone. Lastly, if by chance you have, I know most of you don't, but I don't want to assume, if by chance you have these documents saved like to your desktop or something, make sure that you update your forms. Remember, these are not the only forms that changed. There were 17 changes within forms. So these for sure changed. You want to make sure that you have the most recent version of these forms. All right. So let's get to the questions. So I see here. So first, let's go Samsung. Somebody's signing as Samsung. We don't have your name. If you know you don't, that's you, then let me know your name. It says, I'm in North Carolina. I can use this too to tie commission to contract. If that's a question, let me know if that's a question or a statement. Um, if it is a statement, I would recommend that well, I don't know which one you're talking about, which form you're talking about, so I'll start there. But then the next thing I'll say is make sure that if you are using I don't recommend you use these forms. Every state has their own forms, even every board has their own forms, and the forms they're generally drafted to coincide with one another. So for that reason, even here in Florida, we know that we have a crisp contract and we have an as-is contract, and there are certain riders that coincide with the way that the crisp is drafted and not necessarily the way the as-is drafted. So you want to make sure that you use the same form set when you are drafting your agreements. Next question was, when would you issue a buyer broker to seller broker agreement before you put the offer in writing? Issue it or get it executed. Yes, you want to get it executed simultaneously. Now, remember, you want to get it executed either before or simultaneously, but Rider GG is saying that even if you don't have it signed at the time that you go under contract, it has a default time period of 3 days to have it signed, right? From the time the offer is accepted. All right, so from the time the offer is accepted, we're going to get a compensation agreement executed within 3 days. All right. Let me know if that didn't answer your question. Any other questions? We did good today. We did good today.
Good afternoon.
Yeah.
Trisha, I do have a quick question.
Go ahead.
You mentioned on the compensation agreement about the 15 days that was changed from 30. I
Mhm.
didn't understand that. Is that saying once we turn that in over to the seller, let's say I'm representing the buyer, it's 15 days. I don't know what the 15 days in particular is for.
For this agreement is enforceable, yes, for you to be paid under the compensation agreement. So you need to go under contract. This is saying you get me a buyer within 15 days, I'm paying you the amount that we've agreed to here.
Got it. Okay, so once we submit this for the offer, it's just saying they have 15 days to sign it.
15 days for who to sign what? Let's be clear.
Because I'm assuming the compensation agreement, I send this to the seller once we are putting in an offer. So I'm expecting them to sign it within 2 days, hopefully. So that's why I didn't understand the 15, because a sale can take 30 to 45 days. So I don't
It
know.
extends. See, I'm glad you said it. I was waiting
Oh,
for you to
okay.
say it. So
Okay.
let's continue reading since we have a couple minutes. So let's continue reading that paragraph.
Okay.
Paragraph 4, term. This compensation agreement takes effect when a fully executed copy has been delivered to all parties to this agreement and will remain in effect for blank, if left blank, the 15 days. In no event shall the term extend past the termination date of seller broker's current listing of the property, including any extensions or effective protection periods, except that upon full execution of a contract for sale and purchase by a buyer of the property procured by buyer's broker, the term will automatically extend through the date of the actual closing of the purchase agreement.
Okay. So this pretty much once you get under contract, that takes care of it for you.
Exactly. That's your last
Okay.
line.
Thank you.
All right. Good question. Why isn't there a selection of forms based on a set like you just said? For instance, if I pick, why does it not give me only writers and the other forms? Sylvia, I don't know. I don't own transaction desk. Maybe that's a recommendation for them. Yeah, maybe that's a recommendation for them. It's a good question though. Um, I don't know. I don't know why they don't do that. And probably, if I were to off the top of my head, if I were to just give you an answer without speaking to them, um, for liability purposes, right? Ultimately, you are the practitioner. They don't want someone to say, well, you suggested that I use this particular document. They're not doing that. That they're tech, right? They're not the ones that are drafting these agreements. They're not scanning these agreements for anything. These agreements might not even be enforceable. That's not what Form Simplicity does. Form Simplicity just provides you with a platform to access the agreements. These agreements can be completely wrong. Not my job. Right? So if I were to give you a knee jerk or off the cuff response, that would be the best answer. I'm not teaching you, making sure that I'm not making sure that you select the appropriate document. That's not what it's built for. It's built to house documents. All right. All right. Any other questions? Yes, no, maybe so. All right. Many of you are probably gonna need to listen to this again. Um, we are, yeah, you can put that in there, Sylvie. You can. All right. All right. Make sure that you guys, if you remember to sign up to get text reminders for when we have the class updates, or as well as if there are, and even when the session starts, you should get text updates. Again, I mentioned, Dahlia, I know you mentioned, Dahlia, you mentioned you get text, but not emails or something. Again, we're still clearing up that whole communication breakdown since the text requirements have been heightened, I guess I should describe. So again, just make sure that you kind of make sure that you are signed up to get it everywhere it comes out. Emails, text messages. We don't call anybody yet. All right. Don't think we will be ever doing that. All right, guys. Appreciate you. You're welcome. You're welcome. Make sure you guys get on the recording. What is your specialty or teaching? Do we have a division? Nate, what is your question? So, specialty, transactions, title, lending, transactions themselves. Don't call me for legal. You guys are getting wild. These arguments I'm refereeing nowadays are amazing. All right, guys. Appreciate y'all. I will see y'all next Thursday. This has been great. Later.
Bye.
Bye. Thanks, Jocelyn. See y'all later.
Thank you. Thank you so
You're
much.
welcome. See you later.